Hello friends, today we will start discussion from section 45 of the Indian Evidence Act, expert opinion. I am reading the section first. Opinions of experts. When the court has to form an opinion upon a point of foreign law or of science or art or as to identity of handwriting or finger impressions, the opinions upon that point of persons specially skilled in such foreign law, science, or art, or in question as to identity of handwriting or finger impressions are relevant. Such persons are called experts. So, when expert opinions may be called, on what points, for what opinion? So, number one is foreign law. Number 2 is science. Number 3 is art. Number 4 is identification of handwriting. And number 5 is identification of finger impressions. And who can give the expert opinion? Who are specially skilled in this matter. And the person who is specially skilled in this matter are called the experts. Let me proceed to the illustrations. The question is whether the death of A was caused by poison. The opinions of experts as to the symptoms produced by the poison by which A is supposed to have died are relevant. The question is whether the death of A was caused by poison. The opinions of experts who are specially skilled in this science as to the symptoms produced by application of such poison by which A is supposed to have died is relevant. Now, the next. The question is whether A at the time of doing a certain act was by reason of unsoundness of mind incapable of knowing the nature of the act, or that he was doing what was either wrong or contrary to the law. The opinions of experts upon the question whether the symptoms exhibited by A commonly show unsoundness of mind. The question is unsoundness of mind, whether A was of unsound mind while he was doing such act. The opinion of experts upon the question whether the symptoms exhibited by A commonly show unsoundness of mind, and whether such unsoundness of mind usually renders person incapable of knowing the nature of the act which they are doing, or knowing that what they do is either wrong or contrary to the law, are relevant. So the opinion of the person who can say that whether such kind of unsoundness of mind can render the person in such a state that he is incapable of knowing what he was doing or what is the effect of his deed, or whether it is wrong or contrary to the law, these opinions are relevant. C. The question is whether a certain document was written by A. Another document is produced which is proved or admitted to have been written by A. The opinion of experts on this question whether the two documents were written by the same person or different persons are relevant. Say on a will is executed, supposedly to have been executed by Mr. X. Now, while the will was placed for probate, someone challenged the signature of the Mr. X, that this is not the signature of Mr. X and the signature has been forged. The signature has been forged. Now, there is a signature with the bank of Mr. X, which is admittedly the signature of Mr. X. Now, a person who is specially skilled to tally the signatures can give opinion whether the two signatures, one that is available in the alleged will, and another admitted signature available with the bank, whether both the signatures are of the same person or not. So section 45 is clear. Now, after amendment of Indian Evidence Act, section 45A has been added. Opinion of examiner of electronic evidence. When in a proceeding, the court has to form an opinion on any matter relating to any information transmitted or stored in any computer resource or any other electronic or digital form, the opinion of the examiner of electronic evidence referred to in section 79A of the Information Technology Act is a relevant fact. Explanation: for the purpose of this section, an examiner of electronic evidence shall be an expert. So, by way of amendment, section 45A has been added to the Indian Evidence Act, by which when the court has to form an opinion on any matter relating to any information transmitted or stored in any computer resource or any electronic or digital form, the opinion of the examiner of electronic evidence referred to in section 79A of the Information Technology Act 2000 is relevant. And in this case also, who will examine, whether we will examine the digital information, will be treated as an expert. So it is similar to section 45. It is just an addition of electronic evidence. Now section 46, facts bearing upon opinions of experts. Facts not otherwise relevant are relevant if they support or are inconsistent with the opinions of experts when such opinions are relevant. I am reading again. Facts not otherwise relevant are relevant if they support or are inconsistent with the opinions of the experts when such opinions are relevant. Let us go to the illustrations to understand the section in a better way. The question is whether A was poisoned by a certain poison. The fact that other persons who were poisoned by that poison exhibited certain symptoms which experts affirm or deny to be the symptom of that person is relevant. Death of other person by use of similar type of poison and the symptoms exhibited by them, shown by them, are not at all relevant in a subsequent case, but it is relevant because the experts are affirming that the person on whom such kind of poison is applied, they exhibit similar kind of symptoms. So, though the earlier cases are not relevant, but as it is consistent with the expert opinion, these will become relevant. Illustration B. The question is whether an obstruction to a harbor is caused by a certain sea wall. The fact that other harbors similarly situated in other respects, but where there were no such sea walls, began to be obstructed at about the same time is relevant. I am reading again it is. The fact that other harbors similarly situated in other respects, but where there were no such sea walls, began to be obstructed at or about the same time is relevant. The question is whether an obstruction to a harbor is caused by a certain seawall. Now, a fact that other harbors similarly situated in other respects, but where there were no such seawalls, began to be obstructed. Without any seawall, they were also obstructed. At the same time, it is relevant. Now section 47, opinion as to handwriting when relevant. When the court has to form an opinion as to the person by whom any document was written or signed, the opinion I am reading again. When the court has to form an opinion as to the person by whom any document was written or signed, the opinion of any person acquainted with the handwriting of the person, by whom it is supposed to be written or signed, that it was or was not written or signed by that person, is relevant. Now a question is whether a particular letter was written by my father. I am not a handwriting expert, but I know, I am acquainted with the handwriting of my father. Now, my opinion as to whether this is the handwriting of my father or not is relevant. Explanation. A person is said to be acquainted with the handwriting of another person when he had seen that person write, or when he has received documents purporting to be written by that person in answer to documents written by him or under his authority and addressed to that person, or when in the ordinary course of business documents purporting to be written by that person have been habitually submitted to him. I am acquainted in due course of business. I receive letters from him in reply of my letter, or I used to receive letters from that particular person, or I saw that person to write, and thus I am acquainted with his handwriting. Illustration. The question is whether a given letter is in the handwriting of A merchant in London. B is a merchant in Calcutta who has written letters addressed to A and received letters purporting to have been written by him. C is B's clerk whose duty was to examine and file B's correspondence. D is the B's broker to whom B habitually submitted the letters purported to be written by A for the purpose of advising him thereon. The opinions of B, C and D on the question whether the letter is in the handwriting of A are relevant, though neither B, C or D ever saw A write. A is in London, B is in Kolkata. C is A's PA and D is B's PA. The duty of A's PA was to keep the letters properly in a file purported to be written by B, and B's PA's duty is to keep the letters purportedly written by A to B to keep in a file and advise accordingly. So B, C and D all are acquainted with the fact, with the handwriting of A. Whether or not they saw A to write, so their opinion is also relevant. I think it is clear. Now section 47A, which was added later for digital signature. Opinion as to the digital signature when relevant. Opinion as to digital signature. When the court has to form an opinion as to the electronic signature of any person, the opinion of the certifying authority which has issued the electronic signature certificate is a relevant fact. So in case of forming opinion whether this is the digital signature of Prithwishganguli, the opinion of the certifying authority who has issued digital signature certificate for Prithwishganguli is relevant. I think this section needs no further explanation. So I am going to section 48. Opinion as to existence of right or custom when relevant. When the court has to form an opinion as to the existence of any general custom or right, the opinions as to the existence of such custom or right of persons who would be likely to know of its existence if it existed are relevant. Explanation: the expression general custom or right includes customs or rights common to any considerable class of persons. The illustration will be very much helpful to understand this section in a fraction of a second. The right of the villagers of a particular village to use the water of a particular well is a general right within the meaning of this section. All the villagers use the water of a particular well. So it is a general right. So this will come under the purview of section 48. Next, section 49, opinion as to usages, tenets, etc. when relevant. When the court has to form an opinion as to the usage and tenets of any body of men or family, the constitution and government of any religious or charitable foundation, or the meaning of words or terms used in particular districts or by particular classes of people, the opinion of persons having special means of knowledge thereon are relevant. So it is very easy, this part. Section 50, opinion on relationship when relevant. When the court has to form an opinion as to the relationship of one person to another, the opinion expressed by conduct as to the existence of such relationship of any person who, as a member of the family or otherwise, has special means of knowledge on the subject is a relevant fact. Provided that such opinion shall not be sufficient to prove a marriage in proceedings under the Indian Divorce Act or in prosecution under section 494, 495, 497 or 498 of the IPC. Illustration. The question is whether A and B were married. The fact that they usually received and treated by their friends as husband and wife is relevant. A and B used to visit friends and relatives as husband and wife. They used to reside as husband and wife. So this is relevant to establish their relationship. The question is whether A was the legitimate son of B. The fact that A was always treated as such by members of the family is relevant. The entire member of his family treated B as a son of their family. So this is relevant to establish the relationship. (51) Grounds of opinion when relevant. Whenever the opinion of any living person is relevant, the grounds on which such opinion is based are also relevant. When the opinion is relevant, the grounds based on which the opinion has been formed, that is also relevant. Very easy. An expert may give an account of experiments performed by him for the purpose of forming his opinion. It is relevant. Now, I want to share 3 very nice case laws, so that these case laws will help us to understand the particular provisions of expert opinion part of Indian Evidence Act. The Supreme Court in Ramesh Chandra Agarwal versus Regency Hospital Limited and others case, the court stated that the first and foremost requirement for expert evidence to be admissible, when the expert evidence will be admissible, the Supreme Court stated that the first and foremost requirement is that it is necessary to hear the expert evidence. That means the person who is giving the expert evidence must be present in court. The test is that the matter is outside the knowledge and experience of the layman. The next case law, Calcutta High Court. Very recent judgment. Today is 6th June. Calcutta High Court passed this order on 5th June. That means yesterday. The Calcutta High Court in Aminul Islam versus State of West Bengal case was of the opinion that in case of discrepancy between ocular and medical evidence, medical evidence is expert evidence, expert opinion. Discrepancy between ocular and medical evidence, ocular testimony shall prevail because the medical evidence is in the nature of an expert's opinion. The court was of the view that appellant was entitled to benefit of doubt, and the learned trial judge ought to have recorded an order of acquittal in favor of the appellant, etc. So the main thing which is to be noted, when there is discrepancy between ocular evidence and medical evidence, ocular evidence will prevail over the medical evidence because medical evidence is expert opinion. It was held by the Honorable Calcutta High Court on 5th June, just yesterday. Now, the last one, Honorable Supreme Court held where the opinion of one medical witness is contradicted by another and both experts are equally competent to form an opinion. The court will accept the opinion of that expert which supports the direct evidence in the case. Now, this is a very fantastic point. Two expert evidence, two expert witness on the same point, but they differ in their opinion. Which opinion will prevail? Which opinion will stand? Both are similarly qualified, both are well competent, but their opinions are different. Which one will stand? The Supreme Court observed that the court will accept the opinion of that expert which supports the direct evidence. Opinion of the expert witness that supports the direct evidence, that will stand. This is Pyara Singh versus the state of Punjab in the year 1977. So, in this episode, I have completed up to section 51 of Indian Evidence Act. From my next episode, I will start from section 52 of the Indian Evidence Act. Till then, I will again request you to, if you like these video episodes, please subscribe my channel and share the episodes with your friends and others who are interested in the subject. I will be very happy if my efforts come to your any help. I am always ready and I am always open to answer any of your queries. Feel free to write to me. Feel free to call me. I will be for you with my new episode very shortly. Till then, thank you. Stay blessed.